Good morning. I'm Aaron Hall. We are going live in just a moment. In fact, we're already live, but we're going to take a moment to allow the technology to sync up and allow you to submit your questions. All right, we'll get started. I'm Aaron Hall. I'm an attorney representing business owners and entrepreneurial companies. I do these videos to help empower you with knowledge and education to help you identify issues to discuss with your attorney, to help you avoid problems before you find yourself in the midst of them. And ultimately, the goal is to help you have a more successful life and business. A few little housekeeping items before we get started. Some of you may be here because you've subscribed to this YouTube channel, and that's fantastic. Some of you might be here because you're on our newsletter. And when I say newsletter, it's not a typical newsletter. Basically, you get a list for free of the most common legal pitfalls faced by new companies. And then you get subsequent videos that are only available to subscribers, where I talk about how you can avoid those specific pitfalls in your business and how you can spot issues to discuss with your attorney and to avoid problems down the road. You might say, "Hey, Aaron, are you doing this so that you can get more business?" I'm not. And if you think about it, a very small percentage of the population who watches this channel actually resides in Minnesota. And I'm only licensed in Minnesota. I generally only help people in Minnesota. So this is really about giving back and living our purpose here on earth. And that is to use expertise to empower others. If you've heard my story before, you know that I wouldn't have been able to go to law school and I wouldn't have had the opportunities I had if it weren't for others who came alongside and helped me and went before me. And so I believe that there is a profound uh, principle in life that instead of using what we have for our own self aggrandizement and our own progress, we should use the resources we have to help others. That's why we're here. It's part of life's purpose. And one of the great rewards in life is when we live out that mission or that purpose, we get substantial benefits. Um, some would say what goes around comes around, or you reap what you sow, or the concept of karma, or whatever you want to call it. Um, I believe that when we use what we have to help others, and we're not just looking out for how can I make more money and how can I get ahead, especially when we're operating from an abundance mentality, we reap substantial rewards, as does everyone else around us. So feel free to get sign up for that newsletter at aaronhall.com/free. There's no charge. It'll help you grow your business and avoid common problems. You might also be here from some other social media platforms like TikTok or Twitter and LinkedIn, and welcome. Happy to have you here. Today, I'm answering a lot of legal questions. Most of them are from business owners or related to business law. Your questions come first, though. As a benefit for being here live, you can submit your questions in the comments below. And if you, for some reason, don't have a Google or YouTube login and you're not able to comment, look in the description. There's a little link there where you can submit your questions on a different platform anonymously. All right, keep in mind as you submit questions, your questions are public. YouTube is public. All this information is public. What's on the internet doesn't go away. So please don't share anything confidential. Also, I'm not going to get into real detailed situations here. This is general public education. I'm going to provide educational guidance. But as always, for specific circumstances, you should talk to an attorney who can take the time to understand your situation ask you questions, and give you advice about the law in your particular jurisdiction. Different states have different laws. So it's important that you get legal advice from somebody looking out for your interests, not from somebody like me providing educational information in a generic manner online. Okay, we're about to jump into the first question. Are non-compete agreements illegal in Minnesota? Well, you may have heard in 2023, most non-compete agreements were banned by the Minnesota legislature if they are created after July 1st, 2023, and they relate to employment or independent contractors. Minnesota is joining California, North Dakota, Oklahoma, and Washington, D.C., at least those are the states that I know of, that have banned virtually all employment non-compete agreements. This is huge for Minnesota. It's huge because for years, people have relied on non-compete agreements as a way to entrust somebody with confidential information, knowing that they can't use that to compete against an employer later. Whatever your position's on, whether non-competes should be illegal, that's kind of aside. They now are in Minnesota. There are some exceptions. What are those exceptions? Well, first, there's an exception for the sale of a business, like business owners. There's an exception for merging and dissolving a business, but all of that has to do with the business owners. It is not related to the individual employees. Now, one of the real concerning areas of this law is the fact that it applies to independent contractors. Well, what does that mean? Because if you think about it, any contract with another party makes the parties independent contractors, unless they're employees. I think the legislature meant to apply this not just to employees, but individuals who provide services for the business who are independent contractors. But by including all Minnesota independent contractors, there's no exception for big businesses who have contracts together. I mean, look at it this way. If Apple and Google have a contract that they're going to engage in a particular effort together and that they'll agree not to compete in that space, those are independent contractors. And if they're doing business in Minnesota, at least a significant amount of business, there's an argument that that applies to them. So the courts have yet to figure out what to do about this. And in my experience lobbying the Minnesota legislature, it's quite common for legislation to get through initially and then get cleaned up in subsequent legislative sessions. So it certainly is possible that in 2024 or 2025, you might have some clarity provided on these issues. And if you don't, ultimately it's going to be up to the Minnesota Supreme Court to decide what qualifies as an independent contractor, especially as it relates to large companies who agree not to compete with each other. Will those agreements be enforceable or are they banned? To learn more about this, we'll have a link in the description below. So just to summarize, all Minnesota non-compete agreements started from July 1st, 2023 onward are banned in Minnesota. The ban applies to independent contractors according to the statute. And there are a couple exceptions for essentially buyers and sellers of a business or business owners dissolving their company. What isn't included in the Minnesota non-compete ban? Confidentiality agreements are still enforceable, And that means like a non disclosure agreement where parties agree to keep something confidential. In other words, they have to keep it confidential, but they can still compete with that knowledge in their head. The second exception to the Minnesota non compete agreement ban is non solicitation agreements. What are non solicitation agreements? It's when parties agree not to solicit the employees or vendors or customers of a company. So let's say uh, Emily works for a company and she signs a non solicitation agreement that says for 1 year after leaving the company, she will not solicit the employees, clients, customers, patients, or other relationships of the company. And then Emily leaves and she goes to another employer. Under that non solicitation agreement, she would be prohibited from soliciting those relationships, even though she could still compete in the marketplace. Because although non compete agreements are banned, non solicitation agreements remain enforceable. Next question. Is it illegal to copy someone's work if you change it? So imagine that you see something written up, or maybe you see a video, and you say, you know what, that's great. But what I'm going to do is change the words of it. And then I'm going to put that same video out or same written work out. Or maybe it's even a painting. You see a painting, and you know what? Say, I'm going to change a few things. Instead of having pine trees, I'm going to have aspen trees. Instead of having a cabin, I'm going to have a barn. Is that considered copyright infringement? And the short answer is it's a gray area, but as a general rule, if you are making a copy of something, you are infringing it unless you are so substantially changing it that there is no real connection to the past piece. This has come up a lot recently with music because one artist will have a song and another artist might take a little beat from that song or a little rhythm or a little just a little snippet. They'll borrow a little component of the music and use that. uh, Vanilla Ice with Ice Ice Baby was a famous example from a number of years ago where that little opening sequence, which then played throughout the song, was lifted from Queen, the artist or the band Queen. And ultimately, because Queen claimed infringement, it's my understanding that Vanilla Ice and his group agreed to give all the proceeds or profits from that song over to Queen. That was a settlement, but ultimately they did that because they knew it would be copyright infringement. So, and even if you borrow somebody's idea, or I should say their work, and make a few changes to it, you might have a copyright in those changes. It's called a derivative copyright, but that is still infringing the original owner's mark. So, my advice to people is create your own music, create your own web pages, create your own videos. It's one thing to have concepts that you utilize, but it's quite another thing to kind of copy what they're doing and just try to tweak things to make it look different. Next question. If your business can't pay its debts, what then? What are your options? What can you do? Well, this is kind of a big question. And so let's break it down to the different types of debts first. You might have debts to employees. If you have payroll coming up and you can't afford it, that's a significant issue. You might owe debt to the government for taxes. You might owe debt to a bank who has a lien on your home or a lien on your assets. And then you might owe debt to others like vendors who don't have a lien. The general rule is that you should prioritize your debts and pay them in this order: wages, that's most important. States like Minnesota actually have it a crime if you don't pay your employees' wages. So that's a really high priority, getting those employees paid. Second, pay the tax authorities, income taxes, sales taxes, etc., because usually those are not uh, immediately dischargeable in bankruptcy. And government authorities have much greater power than most creditors to go after your assets, to levy bank accounts, to garnish money that you have. So, second is make sure you pay the government next. Third is going to typically be secured creditors. Secured creditors are people who have a lien on property. And so, if you don't pay off that creditor, then the creditor gets to take the property that they have a lien on. A lien is kind of like collateral, essentially. The property is collateral, and the lien is a property right on that. So here's a great example. If you go have a mortgage with a bank for your home, the bank has a lien on your home. We call it a mortgage. But if you don't pay the mortgage, the bank can take your home. So those secured creditors are the next highest priority. And then everyone else, including unsecured creditors. Often at that point too, you can be selective in which creditors you pay as long as there isn't a bankruptcy in place. So if your business can't pay its debts, one good practice is prioritize the different categories of debts and make payments on those. Another option is to make minimum payments so certain creditors don't cut you off from credit. Also, what you can do is work with a bankruptcy attorney or a workout attorney to see if that attorney can threaten bankruptcy and work out some sort of settlement with the creditors. Maybe that's a payment plan. Maybe it's a lump sum payment using proceeds that would not be available to creditors in a bankruptcy. I have another video on workouts, and you can learn all about the process there, what the steps are involved. So, if your business can't pay its debts, I recommend checking out the workout video that I did, and you can find that link in the description below after this YouTube Live. What can you do about a fake or defamatory online review? The first thing I recommend that people do is ask a group of people to report the review as fake or defamatory or otherwise against the terms of service. For example, if you have a Google review from somebody who says they were a customer, but you have no record of that person being a customer, um, in that case, it might be somebody who's angry at you. Maybe it's a competitor. Maybe it's somebody who has some other issue with you. Sometimes these things just come across randomly, but you can have a group of people who have Google accounts report that review as a violation of the Google terms of service. And often, with enough of those reports, Google will just remove that. So that's what I recommend as a first step. Other options, though, include sending a cease and desist letter to the party involved or bringing legal action, so a lawsuit, and naming Google as a party or this other individual as a party. So that's I kind of follow those three steps. Step one, have a number of people report the review as against the terms of service. Step two, a demand letter or a cease and desist letter. You can see more about that in the description below. Well, after this live, I'll add a link to that. And third, you can bring a lawsuit. And it's important that you name both the owner of the review website, like Google, for example, and if you know it, the person who posted the review. If you don't know that person's name, often you can get it after starting the lawsuit against the web hosting platform, because then they'll share information with you during the course of discovery, and you can learn who that person is, what phone numbers or email addresses they've used, etc. Okay, let's move on to the next question. When does a power of attorney end? The short answer is when somebody dies or when the power of attorney says it ends. Let me explain. A power of attorney is where a person gives authority to another person to act on their behalf. And we call that document a power of attorney. Often it has to be notarized. Some states or jurisdictions might even require witnesses be involved. And it gives authority to this other person to act on their behalf. That authority may be very broad, like buying and selling real estate, liquidating bank accounts, opening bank accounts, etc. Or it might be very narrow, and it might say, for a particular transaction, they can sign on my behalf, or for a particular period of time. A real common one is if a person is unconscious or otherwise indisposed and unable to act on their own behalf, somebody trusted may be able to act as an attorney in fact for them. So let me be real clear. That person is not a licensed attorney. That's called an attorney at law. If you have a power of attorney authorizing you to act for somebody, you are called an attorney in fact. That means factually, for the circumstances stated in the document, you can act on their behalf. Documents, or let me put it this way. A power of attorney often says when it expires. Now, if it doesn't, there is still a way that you can terminate a power of attorney that you've issued. Usually that is to send a notice that the power of attorney is being terminated and delivering that notice to the person who is acting as your attorney in fact under the power of attorney. So when does a power of attorney end? When you pass away, or when the document itself says that it ends. And then, of course, you can terminate it later by delivering a notice to the person, notifying them that the power of attorney is terminated. This is a fun question. What is the best business type for most businesses? Keep it simple. All right, so we could spend all day talking about the difference between corporations, LLCs, and S Corps. But let me just tell you, for most small businesses starting out, an LLC is the way to go. For most businesses that are a little more established or making significant profits, like over $60,000 to $80,000 per year, an S corporation is the way to go. A lot of times LLCs start out and they then later elect to be taxed as an S corp once they start making significant profits. But the best type of business entity type for small businesses on average is an LLC when they get started and later being taxed as an S corp once they're generating significant profits. Of course, there are all sorts of exceptions to that. It's best to excuse me, it's best to consult with an attorney. If a band breaks up, Who can use the songs? The writer, the singer, all the members of the band? This comes up regularly because when you form a band, you're thinking about the fun of the music, you're thinking about creating great music. You're usually not thinking, I'm going to create some incredible music and break up with the people I create it with. And then I'm going to want to use that song. Who has the rights to it? So let's walk through the different pieces here. First, this is all under copyright law. So under copyright law, whenever somebody creates something, an artistic work, so that might be lyrics, it might be the music composition, it might be a musical recording of the lyrics and the musical composition. Each one of those gets separate copyright protection because each one is a work. So let me give you an example. You might have a poem written, which eventually goes into a song. And then you have the musical composition, which provides the tune, the melody, the drums, whatever that might be. And then you have the recording of an actual performance of those. Each one of those gets separate copyright protection. The people who are participating in the creation of it own the common law copyright rights in each one of those works. So if you are jointly creating something together, usually under the law, that's considered a partnership, sometimes called a joint venture, but essentially the same thing. That means you jointly own the rights to that, which unless you have an agreement otherwise, you generally get perpetual use rights. So that means you created it, you get to use it forever. And then second, nobody else, even if they're in the band, would have a right to that. And of course, no members of the general public could use that. But what often happens is one person writes the lyrics in a band. Other people in the band come up with the musical components for their parts. And then so that's the composition. And then it gets recorded. And so now you have the recording owned by essentially the entire band. That band may have assigned rights to a record label. That band might have formed an LLC or a corporation. So, and in those cases, you usually have something in writing, a contract or our operating agreement for the LLC that explains how things are handled. So if nothing's in writing, the general rule is you have a right to continue to use whatever you've created. And if you did it with somebody else, they have a right to continue to use it as well. But contracts can immediately change those default rules. Next question. Is it illegal for business owners to drink on the job? So we're not going to get into whether it's prudent or a best practice. Let's just talk about, is it illegal? As long as there's no company policy that prohibits it, it's usually not illegal. In other words, it is usually legal for a business owner to drink on the job unless the business has a policy that prohibits it, or there's some specific law in your industry or profession that prohibits it. But here's one thing to keep in mind. You're still liable for everything you do, even if you're intoxicated. It's not a legal defense to say, oh, I was drunk, so I shouldn't be responsible for whatever problems I caused or harm I caused or my actions. Whether it is improper speech or conduct or damage to something, you remain personally liable for your personal conduct, regardless of whether you have an LLC and regardless of whether you've been drinking. So, although it's not illegal to drink on the job, unless you have a policy against it or a law against it, obviously it comes with some significant risks. Next question. How can I find out if my business needs to collect sales tax? This is really tough for businesses because the law keeps changing. Every state has different rules, and states keep changing their rules. Really, the only way to find out whether your business needs to collect sales tax is to go to the government department, agency, or office that administers the sales tax and ask them. Now, typically, if you call them and ask, they're not going to give you an answer for your business because they'd have to learn all about your business and what you're selling, but they'll point you to the specific legal guidance for your category of business so you can come up with that decision on your own. This gets really messy because often states don't charge sales tax for services, but then when we get into uh, photographers, for example, photographers provide a service, they take photos. But of course, then when they're done, they provide those photos. And does it matter if they provide them in a physical form as paper photos or in a digital form? And does it matter if it's on a digital USB drive or it's just allowed to be copied from a website? Because if you think about it, if somebody just downloads, they're just making a copy. They didn't actually get some new item. Whereas if they receive a paper document with photos, that could be argued to be the delivery of goods, which is then subject to sales tax. So, my advice with business owners is you're welcome to ask your CPA. They're often up to speed on the latest changes in sales tax law. But a great free option is just to contact the agency in your state government that handles the sales tax and get specific guidance for your business or industry from them. Can a concept be protected by copyright? No, it can't. The expression of a concept can be protected, but not a concept itself. So let's think about this, for example. Say you have an idea to have, let's imagine the Mona Lisa. You have an idea and you tell your friend about that idea. And your friend then goes and paints that. And then you go paint it and you say, hey, you copied my idea. Ideas can't be copyrighted. So unfortunately, you can't claim copyright infringement merely because somebody steals your idea. But if they copy the expression of your idea, now you have copyright infringement. So you might be wondering, well, what if I have a 5-step plan? Can that be, if somebody borrows that, is that copyright infringement? The answer is if they take word for word what it is, yes, that's copyright infringement. But the idea itself is not. So you might then ask, well, what about phone books? I mean, what if one company goes through all the work to create a phone book, but inside the phone book is just an alphabetical order of all the phone numbers and names and addresses of people? Is that protected? That's been a much litigated issue. And the general rule is if it's copied word for word, it is copyright infringement. And one way that companies can prevent such actions is they'll put some fake names and phone numbers in there. And that's how they can tell whether somebody else just copied their phone book or created the content entirely on their own. Maps are much the same way. You know, maps are all just copies of what exists in a geographic location. But you can't copy somebody else's map, and that's copyright infringement. And one way a map dealer dealt with that is the map dealer put a fake location on the map. And when it was later copied, the producer of the map said, "We know that you copied it because this city isn't real." Well, here's something unusual. Because that was there and people were relying on that map for so long, they ultimately did put signs up saying that's the city existed there. And so then the question is, well, if what was really a fake city now becomes a real city, is that copyright infringement? We're getting down a rabbit trail, but you can see the idea here. You are welcome to generate your own maps or directories or lists, but to copy it from somebody else and essentially avoid all the work that's required in compiling that, that is generally considered copyright infringement. Okay, moving on to the next question here. What's the difference between payroll tax, self-employment tax, sales tax, and income tax? It'll probably be apparent once I explain what each one is. Payroll tax is about 7.5% paid by employees and 7.5% paid by employers. And it varies a little bit from area to area, but roughly about that. So about 15% of your total paycheck. And you know how on your paycheck, when you work at a job, there are withholdings on that for Social Security and FICA. That's what we call payroll tax. So half of it's paid by the employees, half is paid by the employer. If you work for yourself, you're both the employer and the employee. So you pay the full 15%. We don't call it payroll tax anymore, though. Now we call it self-employment tax. So it's the same idea. You're contributing money to Social Security and FICA and various government programs. But instead of calling it payroll tax like we do when there's a company and an employee, like a corporation, you are paying it all yourself. You're either a sole proprietor, a partner, or you own an LLC taxed under default rules. And in that case, we call it a self-employment tax. It's the 15% that you pay. Income tax is on top of that. So when you pay income tax, that's for all the money that you bring in, whether it's from a job or some other source. And you pay your federal income tax. And if you have a state income tax, then you pay some money to the state as well. Federally, that might be a 20% tax rate or a 35% tax rate. And then you've got your state percentage coming off that as well. So many people don't realize when they have a paycheck, they're paying payroll tax, state income tax, federal income tax. All that is being taken by the government, which is why when you get your paycheck, there are such significant withholdings. Most people who get their first job take a look at their first paycheck and they say, wait a second, I should be getting a lot more money. But then the employer explains, no, all this money was taken out for the government. All right, so let's talk about sales tax. What is that? Sales tax is when you go buy something at the store and the store collects a portion of money for the state. So if you're not familiar with tax law in the United States, you might be going, wait a second. So when you earn money, the employer takes out payroll tax. When you then pay your annual income tax, that's coming out. Might come out to the state and federal government. And then when you spend your money, you also have to pay sales tax. That's decided on a state by state basis, but the general rule is yes, you do. Without getting too much into the ideas behind it, I have two very strong views on this, and I'll just share my bias with you, and they're conflicting views. I think it is uh, misleading to taxpayers for the government to pull money from all different directions in all different ways because then taxpayers don't realize how much they're actually paying in taxes to the government. But here's my conflicting view. Having a variety of ways for the government to get taxes means that nobody can really game the system. We are able to make sure, or as a government, the government is able to make sure that it's getting taxes from different people in all different walks of life and different arrangements. For example, if the criminal steals $1 million, they still have to spend that money. And so we're at least able to tax the criminal through sales tax. If a person earns money but spends very, very little, we're at least able to get some tax from that person by the income tax. And you might say, well, why do we care? Well, we have to fund roads and fire departments and police departments and all the government agencies. It'd be wonderful if it was as simple as the Wild West, where there are no laws and you don't need anyone to enforce it, or very few laws. But these days we have the amenities of interstates, parks, parks that require maintenance, and the need for law enforcement as we have more and more people and more issues. So, anyway, that's the idea behind why we have all these different tax types, so that even though it may be average citizens don't understand how much they're paying, the benefit is at least everybody is paying and the government's getting people at different points. Next question. Can you draft a contract with ChatGPT? The short answer is yes. But then, how good is that contract? That's really what we're getting at here. I hopped onto ChatGPT and I have tried drafting some contracts. First off, it's amazing how all you have to do is ask it to draft a certain type of contract and it will. And it looks incredible. But it's kind of like me, I don't know much about cooking. If I look at a recipe, I'm not really going to know whether that recipe is going to taste great or terrible. But a lot of chefs and professional cooks could look at that and go, "Oh yeah, there's some there's some problems with that recipe." And you don't really know until the recipe is done, or at least I wouldn't know. And then I taste it and I go, "Oh wow, that's way too much salt," or whatever. And that's the problem with ChatGPT contracts right now. You don't know until there's an issue that requires you to go look at the contract and you see certain pieces are missing or weren't written the way you want. It all goes back to what should be in a contract to begin with. It should be the terms that the parties agree to. So to have some computer spit out generic or default language doesn't mean that reflects the terms that you and another party want when entering into the agreement. It also doesn't mean that all the important terms are included. When I draft a contract for a client, I spend the initial time talking with them about what are the terms that are important, and then next, what are the problems that we might foresee? Like, what are the hypotheticals where this relationship may not go well? We want to make sure then that those worst case scenarios are somehow addressed and problems are mitigated in the contract. That might be a framework for dispute resolution. It might be an agreement on how certain issues will be handled. It might deal with intellectual property rights and who owns them. So I've thought about doing a online course for people on how to use ChatGPT to draft contracts. And I'd be very interested to know if that's something that you would be interested in, and want to attend and find valuable to you. A course on how to use ChatGPT to draft contracts would need to talk about what is the process to assess what terms should be in a contract. Um, what are common mistakes in contracts? And then how do you design the prompts for ChatGPT to draft that type of contract for you? And then, of course, you have to look through that contract afterwards to make sure ChatGPT did it right. I think it's really cool how AI is going to improve in the future. Right now, it's an incredible tool to use at the front end to kind of brainstorm. But so far, I have been incredibly disappointed with ChatGPT's ability to produce high quality legal documents or legal research. In fact, the biggest problem I've had is ChatGPT just makes stuff up, it seems. Some people call those hallucinations. For example, I might say, hey, ChatGPT, are there any cases that stand for the proposition that, and then I put some legal argument in there. ChatGPT says, yes, there are, and here are the cases, and here's a summary of those cases. I look at those cases and it says nothing about the issues that we talked about. I get it. ChatGPT needs to produce some results. There must be something in its programming that says produce the best content you have available rather than err on the side of precision and accuracy. Whatever it is, I don't understand the coding behind the AI software, but the computers are not yet at the point where we can rely on them for this without significant guidance, oversight, and quality control. So if you're interested in a course online about how to draft contracts using ChatGPT, I'd love to have your feedback. And if you could tell me the types of contracts that would be relevant to you, that would help me design the course in a way that would be useful to you. Are there special bankruptcy protections for business owners? There is a huge protection for business owners who need to file for bankruptcy. And let me give you a little context so you understand what it is. Usually, you cannot file for bankruptcy if you make too much money. So, for example, let's say you have children, 2 children, and you're married and you make $100,000 a year. You would currently not qualify for bankruptcy under Chapter 7. That's kind of what we think about as the basic bankruptcy, where you can just discharge all of your debts. And the reason you wouldn't qualify for Chapter 7 bankruptcy is what's called the means test. The means test determines whether you make too much money. In other words, do you have the means to repay the debts or not? But there is currently in 2023 and for many years now, an important exception for business owners. When you have substantial business debts, where the majority of your debts, let's say, are from the business, you don't have to be subject to the restrictions of the means test. This means that you, as a business owner, can discharge debts even though you have substantial income. And let's face it, there are a lot of business owners that actually have a fairly high income, but they also have high debts. And for example, when COVID occurred and many businesses were devastated, many business owners took advantage of this important exception in the Chapter 7 bankruptcy code, which allows business owners with high incomes to file for bankruptcy and discharge all of their debts. All right, let's move on to the next question. Again, if you have any questions, feel free to add them in the chat box below. How do you start a sole proprietorship? It's really easy. You just start operating in a way that you're making some money and running a business. So, for example, when my daughters opened up a lemonade stand on the corner, they had a sole proprietorship. You don't have to file anything, you don't have to do anything except start running a business. If you start running a business, you are a sole proprietorship, unless you do it with somebody else. Then you're a partnership. Now, if you set up an LLC or a corporation or some other business type, now that business is no longer under a sole proprietorship or partnership, it's under an LLC or corporation. But it's really cool. You can just start running a business, throw something up on Etsy, sell something on eBay, and you are immediately a sole proprietor. You don't have to file anything. And here's something really important: sole proprietors can deduct business expenses on their tax return. It's on Schedule C. This is powerful because if you're not sure you're going to be serious about a business, you don't know if you want to set up an LLC or a corporation, you can just start running the business as a sole proprietor. And let's say you have $10,000 worth of income, but $5,000 worth of business expenses. You can deduct the business expenses from your income, and the remainder is considered your profit. And you only pay income tax on the profit. In other words, you only pay income tax on the $5,000 of profit, not the $10,000 of income, because you're able to deduct the $5,000 of business expense from the $10,000 of income. So it's very easy to start a sole proprietorship. You just start doing a business. What is a default judgment? A default judgment is a decision by a court that one party is liable, even though they may never have even responded to the lawsuit. So, for example, if one party sues another party and that person doesn't respond, the person who initiated the lawsuit can ask the court for a default judgment. That essentially means, court, I want you to judge in my favor by default. I don't have to do anything more necessarily because the other party failed to respond as required by law. Now, usually, though, judges will still require you to establish certain elements. You have to prove that you have enough evidence that there actually were damages, that you actually gave notice to the other party of the lawsuit. That's called service of process. So there are still court rules that apply. But a default judgment is when a judgment or a court decision, you could say, is issued by default because another party fails to respond. How do I contribute money to my LLC? When you have an LLC and it has $0 in it, you just open the bank account. The bank might require you to put some money in the account to open it. So, how do you contribute money to the LLC? You just write a check to the LLC, or you give some of your own cash to the LLC, and just keep track of that. And here's why: when that money comes back out to you, you shouldn't pay income tax on that. So you want to make sure that whatever money you put into an LLC, that's called a contribution, is not taxed as income to you when it's paid by the LLC out to you. So it's really simple. When you want to contribute money to your LLC, just write a check to the LLC or give it cash. It's just like if you were to contribute money to a friend. You can transfer money into the account, write a check, cash, whatever it is you want. And then assuming that LLC has a bank account, the LLC can just keep that money right in the bank account. Just keep track of the finances separately, because if you don't, you can lose the limited liability aspect of your LLC. As you know, limited liability company is what LLC stands for. That means that you're not liable for the acts of the LLC. But one of the ways you can be liable is if you don't keep separate bank records between the LLC and your personal finances. Do content creators traveling internationally have to pay US income tax? So let's clarify here. If you are a US citizen and you're a content creator and you travel to another country where you film and do work and then generate revenue from that work, do you have to pay income tax on that? Yes, you do. Unfortunately, or fortunately, as an US citizen, you must pay income tax on all income you have from whatever source derived. In other words, no matter where you get it, it doesn't matter whether it came from one country or another country, you still have to pay income tax on that. And as you may know, that's one way the government has gone after criminals who make income illegally. So let's say, for example, somebody sells $1 million worth of drugs illegally. The IRS can go after them and prove, even though they may not be able to prove that the person engaged in the illegal sale of drugs, if they see $1 million coming into the bank accounts and no taxes were paid on that, that uh, that person can be charged with tax fraud for failing to report and pay tax on that income. So if you're a US citizen, you need to pay tax on any money you receive anywhere, unless an exception applies under the tax code, of course. Does a revocable trust protect assets from creditors? This is an area where I see a lot of confusion, and I'm going to try to clarify it really simple for you. If you create a revocable trust, it does not protect your assets, which are now in the trust, from your creditors. But a revocable trust does protect the assets in the trust from the creditors of your beneficiaries. So here's an example. You put $1 million into a revocable trust. You then get sued by somebody for doing something wrong. And the court says you owe $500,000. Because the trust is revocable and you owe $500,000 to somebody, that the money in that trust is available to the creditors. You have a right to use that money and to pay off your creditors. But once you've passed away, that trust is for the benefit of your beneficiaries. And you can design a revocable trust that's revocable by you to still protect what's in the trust from the creditors of the beneficiaries. So, say, for example, your daughter is a beneficiary of the trust, and at the age, or let's say the trust says, at the discretion of the trustee, the money will be dispersed to the daughter. And the trustee is not the daughter in this hypothetical. In this case, let's say the daughter gets sued and a court says she owes $1 million. Does she have to pull out the money from the trust? The answer is no. The money's in the trust. It's subject to the trust rules. The only way that the daughter can have to turn over that money to a creditor is if the money is distributed to the daughter. Then it becomes available to her creditors. So, to summarize, does a revocable trust provide creditor protection? It does not provide protection against creditors of the person who created the trust. That's called the trustor or grantor. But a revocable trust does provide or can provide creditor protection for creditors of the beneficiary. How does a single business owner have a shareholders meeting or an owners meeting or a members meeting? So, as you may know, owners of an LLC or a corporation are supposed to have regular meetings. But how do you meet with yourself? The answer is quite simple. You just need to put on a document that you held a meeting and what you decided. You don't need anything more than that. Well, I guess the date, and you should sign it. But it's quite simple. You can make it up after the fact, but you just want to make sure that on a regular basis you're having a meeting, meeting with yourself, and you're making some decisions, whatever those may be. And by the way, maybe it just says you reviewed the company, no changes are needed at this time. Or you reviewed the company and the financials, and as shareholder or as the sole shareholder, you've determined the company should continue operating as it has been under the direction of the CEO or president. Again, that's probably you. So a lot of times people just don't do these. I'm not aware of any case that has actually said you have to do them, but uh, there are at least some cases that say if you do this, it can be a factor considered in your favor when determining whether to pierce the corporate veil. What does that mean? It means whether to hold you personally liable for the acts of the LLC or corporation. In other words, if you create meeting minutes on an annual basis, that at least could be evidence that you treated your LLC or corporation separate from yourself, so you shouldn't have personal liability for the business's contracts or other liabilities. If a trust and a will conflict, which one wins? There isn't a simple answer to this, and here's why. A trust applies to all the assets in the trust. A will applies to all of the assets outside the trust. So, a will and a trust, I can't even think about a hypothetical where they would conflict because a trust has all the rules for assets inside the trust. The will has all the rules for the assets that are not in the trust. So, it's kind of like you could think of it as even two separate businesses. What do you do if the bylaws of one business conflict with the bylaws of another business? Well, that doesn't really make sense because the bylaws apply to that business alone. Likewise, the rules of a trust apply to what's in the trust. The rules of a will apply to everything outside of a trust. So, a will and a trust really don't conflict. You just have to decide, is the asset at issue in the trust or not? If it's in the trust, you follow the rules of the trust. If it's outside the trust, you follow the rules of the will. What contracts does a new business need? When I sit down with clients who have set up a new business, I usually ask them about the big relationships they have. And usually they have relationships with customers or clients. So you're going to have some sort of contract for that. And it might be a simple, client agreement or new customer form, or sometimes it's just a quick little sheet with a few key terms on it. And then you, as a business owner, probably also have contracts with suppliers, independent contractors, vendors, uh, somebody that's providing you the stuff that you need to run the business. Sometimes there's already contracts out there. Like if you want to use Google's email suite called G Suite, you just accept Google's terms of use. You don't actually write up a contract for that with Google. So that's kind of an easy example. You don't need something special for that. But if you have other relationships that are significant and there isn't anything in writing, You would think about, does it make sense to have a contract in writing should there be any sort of problems? You might say, well, how do I know if there are problems? We brainstorm. What are problems that could arise with this important relationship? For example, who will own the intellectual property that they produce? How much will you pay? When will you pay? Um, what happens if there's damage to something? Who's responsible? All that kind of stuff gets handled in those contracts. Then you might also have people who work with you. Those would be employees, independent contractors, or business partners. And you want to have something in writing with them. Usually, for independent contractors and business partners, you have a contract that can go by a number of different names. For example, an independent contractor, you'd have an independent contractor agreement. With a business partner, you might have a partnership agreement or an LLC member agreement or a corporate shareholder agreement, something like that. With employees, you generally don't have a contract. In fact, you often want to say, we don't have a contract, but you are allowed to have employment policies. And in light of the fact that employment policies change from time to time and need to be updated, business owners want the right to change those without having the employee have to approve them. Think about it. In a contract, the other party has to agree to any amendments. So that's one reason why I encourage companies to have employment policies with their employees, not employment contracts with their employees. So, what contracts do you need? Think about the big relationships that you have in the business. Who supplies stuff to you? Who do you supply stuff to? And who are you working with? If you don't have contracts or some sort of written document around what that relationship looks like, the expectations, uh, the terms, and how you'll interact with each other, if uh, if you don't have that, you may find conflict later and frustration later and legal problems later. By the way, even if you don't have something in writing, you probably have something orally spoken. And in that case, if there's ever a dispute, it comes down to he said, she said, who said what. And that's why it's always better to have it in writing, or virtually always better, because at least everybody can look at that piece of paper and see in black and white, here's what we've agreed to. It's undisputed. And that might even be just emailed to each other, or maybe it's signed, but you have something where you're talking about expectations in advance to avoid problems down the road. All right, let's see. Any other questions? What advice do you give to new entrepreneurs? When I was growing up, I had a dad who had a lot of sayings and I love that because it went back to here's what we stand for, here's what's important. Um, one of his sayings was live pure, speak truth, right wrong, follow the king. The reference of the king, we're Christians. That's what that meant. The idea was to do what's right and do what you can in your space. When I had daughters myself, I spent a little time thinking about what's most important to me. And personally, here's what I came up with. It's important to love God and do what's right because it's the right thing to do, not because you benefit from it, not because of any laws or rules, etc. So love God. Number 2, love others. And number 3, seek wisdom. 1 and 2, that's from the Christian Bible, the first and greatest commandment, love the Lord your God with all your heart, mind, soul, and strength. Number 2 is the second commandment, love others as yourself. But the third part is a theme that I think really helps constantly improve in life, and that is seek wisdom. And I think that applies no matter what your life philosophy or religion or faith is. Seeking wisdom allows a person to continue to get better and better and better. And obviously, if you're not seeking wisdom and you're only learning from the school of hard knocks, that's an expensive and painful way and slow way to progress and evolve as humans. If we want to get better and better, it takes continuing to learn. And so, one piece of advice I have to young entrepreneurs is continue to seek wisdom every day in every and as Warren Buffett says it's very incremental. It's kind of like putting away a little money every day into a bank account. It builds over time. It's pretty rare that we have um, moments in life where we grow in wisdom and knowledge and insight in a huge increase. It's typically insight upon insight upon insight. And so seeking wisdom and committing to that every day and doing that from experts and leaders to me is a really great long-term investment in yourself and you as yourself. You are the greatest investment you can ever make. Second little practical tip I often give is make your mistakes working for somebody else before you start your own business. A lot of people start a business, and because they haven't worked in business, all of the mistakes that we all make when we're new in business ends up hurting you as the business owner. But if you go work for somebody else, you're making your mistakes for somebody else. You still get a paycheck. You're also hopefully learning best practices and insights. And I think of every job as paying you some money, which is great, but far more valuable is what you're learning from the job. And every job you can learn from in some way until you've learned that lesson. I worked at a Burger King, I worked in a paper bindery. I had a lot of really rough jobs. Picking berries, I'll never forget shoveling manure on a farm and how as the sun heated up the barn, the steam came up from the manure. And I said to myself, I need to get a job where um, I can use my mind more than my arms and my muscles here, and where I can enjoy the environment that I'm in. So all that to say, use the initial jobs you have as an opportunity to learn. And unless you have just an incredible idea, usually it's best not to start a business as one of the first things you do. So, those are a few things that I try to pass along to others that have really helped me seek wisdom first and make your mistakes learning and working for someone else. Is a similar song copyright infringement if it wasn't copied? This came up recently with Ed Sheeran, where there was an interesting similarity between what Ed Sheeran had wrote in a song and what another artist had written. And ultimately, the court decided Ed Sheeran did not infringe that copyright. Why? The court determined that Ed Sheeran had independently come up with the song. It was not inspired by or copied from the artist who sued. Why is this so important? Because it means that if you create music, you own the copyright to all of that music as long as it's not copied from someone else. It is okay if two artists independently come up with virtually the same work, whether that be a painting or a song or whatever, as long as it's not copied. So, copyright infringement is when somebody copies the work of another without authorization. Do you have a right to photos of you? This recently came up in the news when Prince Harry and Meghan Markle, his wife, were chased by paparazzi and photographed in their car. And this, of course, brought up all those memories of Princess Diana dying from a paparazzi car chase. And in response to photographers shooting photos of Prince Harry and Meghan in the car, their office sent a demand letter to the photographers demanding the photos. So the legal question today is, do you have a right to photos that somebody else takes of you? The general rule is no. A photographer owns the rights to those photos. Those photos were created by a photographer. The photographer owns the rights. The photographer doesn't have to give them to the person who is featured in the photo. Now, you might say, well, that doesn't seem fair. What would happen if I could just go take a picture of Tom Cruise and then I feature Tom Cruise and that photo on my website? Well, there's a separate law that prevents that. And that is Tom Cruise owns the rights to his image, and you are not allowed to associate his image with your products or services. You're not able to use his image in a commercial manner. You could use it, for example, in a newspaper publication if you're covering a story. So, although there are separate rights that a person has when being featured in a photo, the person featured in a photo does not have a right to take the photos from a photographer. It is the photographer who owns the copyright and the right to possess the photos taken by that photographer. If you're interested in learning more about that topic, I'll put in the description below a link to the story about Prince Harry and Meghan Markle demanding the photos from the photographer and the response from the photographer's company, which is written with a little bit of satire on why they don't have any legal obligation to turn over the photos to Prince Harry. What can you do if you are being pursued for a debt after filing bankruptcy? So here's the scenario. You have a debt, you file bankruptcy, then the creditor who you had a debt with pursues you and sues you. What are your options? You might think, wait, I filed for bankruptcy. They can't sue me. That's probably true. At least in many jurisdictions, that's true. It's especially true if they were listed as a debt to be discharged in the bankruptcy. But even if they weren't, in many jurisdictions, that debt is still discharged, but you're getting sued for it. So, what do you do now? Well, quite simply, you have two options. You can either bring this to the attention of the judge in the lawsuit where you just got sued by filing a motion, or, and this is the more powerful option, you can file a motion in the bankruptcy court where your bankruptcy was heard. Those are your two options. Can you use a business EIN to get a credit card? Yes, you certainly can. You can use your social security number to get a credit card, but if you want to get a business credit card, you use the business EIN and probably your social security number as well. This applies to officers, directors, the president, the treasurer, the secretary, any employees, anybody in a business, whether a large business or small, can apply for a credit card under the name of the business. Now, one thing to keep in mind is you might be personally liable for that debt under the credit card. So pay attention to whether there's personal liability or a personal guarantee. Generally speaking, the business is going to be liable if the credit card is under the name of the business, but you may also be liable as a personal guarantor of the credit card application. What is a registered agent? A registered agent is the person designated by an LLC or corporation to receive lawsuit documents on behalf of the business. So if you are suing somebody, you can either sue or deliver those lawsuit documents, it's called service of process, to the person or the business or their registered agent. Every state has different rules about this, but generally speaking, if there's a registered agent, that is at least one way you can serve official lawsuit documents on a business. What is an officer of a company? Corporations and LLCs have leaders in the company who by law are considered officers. And generally it's 3 positions. It's going to be a secretary. That's the person responsible for keeping all of the official records. The treasurer, that's going to be the person responsible for keeping all of the financial documents and filing those documents or tax returns on behalf of the business. And then third, the chief executive officer or president. Now, those 3 duties may be under one individual person. Maybe that's under Emily Smith. Emily does all of that work. Well, that's okay. Emily is the treasurer, secretary, and president. And she can, instead of calling herself president, she could call herself CEO. She can use a lot of other titles because she probably is doing a lot of the jobs in the business. Even if you don't have a designated person who's named as officer, the law generally says whoever is doing those duties is the officer. So an officer in a company is the 3 highest ranking people doing those duties. And again, it can be the same person, and a company can add more officers. You can have as many officers as you want in a company. The company can designate those people and what their authority is. All right, looks like we have about 5 questions left. We're going to wrap up here shortly. If you have a question, feel free to get it in. I'll do my best to get to it. What is a member in an LLC? Quite simply, a member is an owner. In LLCs, we call owners members. In corporations, we call owners shareholders. So just like a shareholder owns a corporation, a member owns an LLC. So member is just another name for owner in an LLC. What is a treasurer of a company? A treasurer in a company is the highest ranking legal role, except for the president, who is in charge of the financial matters of the company. That person might be designated treasurer, or they might be simply doing the duties of a treasurer, and thus under law, the law determines they are the treasurer. So if you are responsible for the financial matters in a company and tax returns, etc., and you're working in that company, you're the treasurer. What is an EIN? EIN stands for Employee Identification Number. Actually, you know what? Let me double check that real quick. Employer Identification Number. So let me say that all again. EIN stands for Employer Identification Number, which means a company or employer has a tax ID, kind of like a social security number. The IRS issues the EINs. Just like in the United States, every person generally gets a social security number. A company gets issued an EIN, or employer identification number, by the IRS. That is a number that you're regularly providing to people who you do business with so that they can properly file their tax returns. So, an employer identification number is essentially a tax ID for a company. What is a fiduciary duty? A fiduciary is somebody who is responsible for another. And so there are certain duties that person has under law to the person they're responsible for. Typical fiduciary duties include the duty of loyalty, so to act in that person's best interest, not in their own best interest. The duty of good faith, so to operate in a manner that's essentially um, trans not transparent, but honest and with integrity, and not for a malicious purpose. The duty of care is another fiduciary duty. The duty of care means you should act as a reasonable person would and care for the things within your um, capacity or within your possession or your control. A fiduciary also has the duty of honesty. And that at least means being honest when asked about something. And often it also means being candid and proactively sharing information that you know the other party would want to know. So, for example, an attorney is a fiduciary of the client. So, an attorney has a duty to do what's in the client's best interest. Be transparent with the client, be honest with the client, be careful with what the attorney is doing for the client, and be uh, honest and even candid in disclosing everything the attorney reasonably believes the client would want to know. Likewise, business owners have fiduciary duties to each other and to the business. Uh, there are all sorts of relationships that involve fiduciary duties, and that essentially is a category of relationship where the law imposes implied duties on the person who's caring for another. How do you prove you own a business? A number of states require the business owner to be registered with the states, but a lot of states, like Minnesota, do not require the business owner be listed in the business registration. It's an issue of privacy and confidentiality. So, if you're a business owner and you're not listed in the state records, how do you prove to somebody that you own the business? Well, there are a few ways to do this. First, you can send them a copy of your operating agreement. Most LLCs have an operating agreement, and if you don't, and you're the sole owner of a business, you can put that together yourself or hire an attorney to do that. Second, you can prove that you are the owner of the business by providing membership interest certificates. An LLC has the option of creating interest certificates like stock certificates that show who the owner is. Third, you could provide tax documents. For example, if you filed a tax return, you could provide that to somebody to prove that you own a business. You wouldn't want to send that to everybody, but maybe a bank if you're trying to get a bank loan. Fourth, you could provide an affidavit. An affidavit is a document signed under oath and usually notarized, which says something. And by putting that under oath in writing, other parties can rely on that. So it might say, for example, I, Aaron Hall, am the owner of um, Blue Smith LLC. It's notarized. I could provide that to somebody as evidence that I'm the owner of a business. Now, in Minnesota and many other states, you can provide an additional document. This document doesn't actually say you're the owner, but it says you have the authority to act on behalf of the LLC. This document is called a statement of authority. And so you can file a statement of authority with the Secretary of State and then provide copies of that to businesses. That way you can keep confidential who the owner is, but you have a public document stating that you are authorized to act on behalf of the LLC. All right, that looks like we have gotten to the end. Looking to see, we don't have any other questions waiting. If you found this YouTube Live helpful, I would love to hear your comments in the section below. If you have any constructive feedback, please feel free to provide that. I am somewhat new to this, and I'm working to provide value that's relevant to you as business owners and other listeners interested in entrepreneurial and business topics. It's my goal to demystify business law so that people have practical understanding and are empowered to run their business and avoid legal problems and hopefully experience a better business and a better life. If you'd like to learn more about me, you can go to aaronhall.com. If you'd like the free videos that I send out only exclusively to subscribers, you can get them at aaronhall.com/free. And if you'd like more content like this, you are welcome to subscribe to this YouTube channel, and you will be notified next time when we go live, which I expect will be quite soon here. Thanks for joining me today.